we got a few minutes. Let's start off with some Q&A that came in advance. We were bouncing this idea around earlier, Bill. Can a common law party change the locks on the other party? You should get a court order, definitely.
Or do mediation.
Yeah, keep it out of
But
court.
if one of the parties is a locksmith, it's different.
But you know,
It's
I
certainly
think,
frowned upon.
yeah, I was saying, Adam, if the person goes out for milk and you change the locks, you know, that's not going to look good. If the person hasn't been around for 4 or 5 months, right? They may have lost the right to possess the home, and the other person's entitled to some security and some privacy.
Right. It's got, yeah, it depends on the circumstances, I think.
Right.
And, you know, the length of the relationship, you know, how long have they been living in the house for? I think it all depends on, you know, the facts of the case, right?
I think you need at least to give them some notice, right? I've had
Yeah.
clients who've been locked out of their homes. They have, you know, a change of clothing and that's it, right? And certainly not a good way to start a file off. So I agree.
And then
with
the
that.
opposing party had the nerve to have him arrested just because he was found nude in the garden looking through the window.
Bill, you're not supposed to talk about your own personal case.
My first wife left to get a pack of smokes and she never came back.
Can you blame her?
No, but I think I'm a better person now.
Because you're not smoking. Oh my, it's gonna be a rough ride today, Steph. Sorry about this.
Steph, is Margie your articling principal?
Yes, I'm super excited.
She is awesome. Just, I'm sure you know that.
Yeah.
She knows a lot. You'll be learning amazing stuff.
Yeah, I'm looking forward to it.
We got a minute. Let's slip in one more question. All right. So common law partner owns the home. Can they remove, evict the other spouse? This is a common question, right? Like it may seem funny, but we get this.
No, I know. I don't know the answer.
Right?
I don't know the answer.
It's-
I'm thinking it's
yeah,
gonna be
it's
real
not
hard.
black and white, right? It's not black and white. It's just, I think, you know, Russ and you and I were talking about this before. Sometimes we've seen cases whereby this is okay, and sometimes we've seen cases where it's not okay. But again, I think it depends on the circumstances.
Well, eviction is usually pursuant to, you know, the Landlord Tenant Act, and then they're going to kick you over to family court. So the family court's not going to, I don't think, issue an eviction notice. They might issue a writ of possession or a restraining order of some sort. But you know, if they were a tenant, they would be hard to remove, right? They still have some basic rights, especially.
Yeah, rights. Yeah.
Yeah. So, but the emotions run high, right? People are separating, they're upset. It could be infidelity, lots of retribution in these actions. So my advice, and we're not giving advice, is do not do anything drastic. Maintain the status quo, get an agreement in place. You can't try mediation, keep it out of court. If necessary, take it before a judge. The stuff, we got 12 o'clock on the dial.
All right. So welcome everybody. Thank you so much for joining our presentation today. We're going to be discussing common law separations, rights, and obligations. So my name is Stephanie. I'm an articling student at Russell Alexander Collaborative Family Lawyers. And I'm just going to start off with some introductions and let you know what's going to be on the agenda for today before passing over the mic to our panelists. So as we are presenting virtually, we do apologize in advance for any technical issues that may come up. I'll be available throughout for any questions or tech issues. So if you are having any challenges, just contact me. My email is Stephanie with a PH at russellalexander.com, and I'll do my best to help resolve the issue. So in this 1 hour presentation, Russ, Adam, and Bill will be sharing their insights on the following topics as it applies to common law separations. So the arrival of the toothbrush, definition of spouse, the main similarities to marriage, how common law couples are different than married couples, child support, spousal support, property, joint family ventures, parenting rights and responsibilities, when common law couples separate, and the limitation periods for common law partners. So there will also be a question and answer portion at the end of the webinar. So if you haven't already, please submit any questions through the Q&A box, and we'll do our best to get your question covered during the presentation. Just a quick note, we have made the Zoom settings in a way to allow you to remain anonymous to other attendees, which is why we've disabled the chat function, but you can still send in your questions through the Q&A box for our team. Also, please keep in mind this content is to provide you with general information. It's not considered legal advice. We'll be providing links to helpful resources mentioned throughout the event in a follow-up email, so you can keep an eye out for that. So now on to some great lawyers, some amazing introductions. It's my pleasure to announce the hosts from the Greater Toronto Area. We have Russell Alexander, Adam Borer, and Bill Rogers. Adam Borer, what a handsome fella. So Adam is an associate
Did
lawyer
he
at our
pay you to
firm.
say that? He did, didn't
No comment.
he?
Adam is an associate lawyer at our firm, and he practices in all areas of family law, including collaborative family law, divorce, child support, spousal support, domestic contracts, and property-related issues. Adam represents clients in litigation, negotiations, and various forms of family dispute resolution. Adam was called to the bar in Ontario in 2013 after graduating with honors at Bond University in Australia. So prior to joining our team in 2015, he practiced both family and criminal law. And if he's not working with clients, he'll be found spending quality time with his family or playing sports. Another handsome fella, Mr.
Oh
Bill
my God.
Rogers.
Now I know you've been paid off.
Bill is a managing associate lawyer at our firm. He believes expertise and compassion are both essential in helping clients get through their family law issues. Bill's courtroom experience includes numerous motions, several blown out trials, and he's also had the privilege of winning a major family law victory at the Ontario Court of Appeal. Beyond litigation, he favors out-of-court solutions and collaborative law. Bill is also an award-winning journalist, published in The Lawyer's Weekly, National Post, and the Globe and Mail. And when he's not practicing law, he loves spending time playing music with his band. Bill, what's your band's name?
It's Soul Custody, S-O-U-L, but under the circumstances, I may have to change it to Soul Decision-Making Responsibility with
Right.
new changes.
Gotta keep it
Okay.
updated.
Contact order.
Contact order, live.
Beautiful. And now on to Russell Alexander. He is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and experience in collaborative family law. He uses his expertise with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. So now that you know a little bit more about our team and what we have on the agenda for today, I'm going to hand things over to you, Russ, and take it away.
Not going to let you go yet. There's a couple quick questions came in. Put your questions in. We love it. Somebody says, who hasn't been found nude in a garden? Well, I guess you'd have to be here for the water cooler session to understand that answer. I only have a question about assets and separates. You guys get involved in real estate litigation and common law separation. So we're going to cover that off when Adam talks about property. We're going to run a poll question. We're going to throw it on the screen. Some of the feedback we've been receiving from previous live events are the polls are great because you get a chance to interact. Also give us an understanding of who our audience is. So please put your poll questions in. Send your Q&A. We'll try to answer as many questions as we can. You'll get a survey and a request for some feedback at the end of this. Please provide us with your feedback. This program actually was the result of a request from an audience member to present on common law. So your feedback is deeply valued. Great turnout today. I think we had about 140 people sign up. So thank you everybody for coming back. And Steph, can we offer our guarantee today? I know you're new, but can you put it out there?
I am familiar. So we do offer a money back guarantee on our free webinar. So if you want to pursue that, just give me an email.
How can you go wrong, right?
Can't go wrong.
And we'll make sure we end at 1. All right, so let's take a look at our poll today. What's your reason for joining us? Maybe we could run the results and see what we got. All right, 67% law professional interested in learning more. 18% professional and other field. Currently going through a separation, 14%, and other, and you can put your other in the comment box. So fairly strong professional crowd today, which is great. We can have a higher level discussion. We're going to do one more quick poll, and then we're going to get the pleasure of Bill talking about what are you talking about? The charades or something?
The Crusades.
Charades. All right, poll number 2. When should a couple be considered in a common law relationship? So you've got a couple choices here. After 3 years of cohabitation, if they have a child together, when the toothbrush shows up, when one spouse gives up their house or apartment. So the toothbrush, you have to give props to Phil Epstein. This was his tongue-in-cheek way of analyzing the case law in terms of determining when the actual relationship starts. So if you've got a toothbrush at your spouse's place, good chance you're in a common law relationship. But we certainly miss Phil. He was a real asset to the practice of law and the profession. Let's see what our results are. All right, 55% after 3 years of cohabitation, 37% if they have a child together. When the toothbrush shows up, only 4%, like my toothbrush thing. Or when one spouse gives up their house or apartment, 4%. All right, let's make a start. Bill, what you got for us?
Well, the interesting thing about common law that a lot of people don't know is it's not the same as being married. Well, certainly not in Ontario. If you're married and you break up, property gets split up according to a formula called equalization. And basically that they look at what you had when you got married and what you had when you separated, and they take the two numbers, one for each person, and they equalize them. So they make sure you're both up by the same amount. And that is what happens when you're married. When you're not married, you don't get that automatic equalization formula. You basically have to use what they call trust law and make what they usually call a joint family venture claim. And then you have to kind of prove that you deserve to share in property, because there has to be a link between you and the property. And trust law is an ancient concept. This is completely useless information, but it started with the Crusades in England, where someone would leave England and go fight, and they would put their property in the hands of a friend. They'd sign it over and they'd say, when I come back from the war, give me my property back. And a lot of times when they came back, their friend wouldn't. They would renege. So they'd have to go to court and do what they call a trust claim and say, my friend was holding my property for me in trust. Give it back. And that's how trust all started. So that's what you do now if you're not married. But there's no requirement that you have to go off to fight in a war.
Good.
Yeah, although maybe there should be.
And there's a lot, we could do a much deeper dive into the various trust concepts, right? You got constructive trust, resulting trust, joint family venture. We've got a common law program, 202, or with 201, which is advanced subjects, where each one of these we could easily spend an hour on. But let's go to our next poll question, because we haven't done a poll for a few minutes. Thanks for that introduction, Bill. So poll number 3, we have, let's see what it says here. If a couple dates and vacations together, but never buys a place together, and both spouses keep their own residences, should they be considered common law spouses? It almost sounds like a law school question, right? So they're dating, they don't buy a place, they both have their own place. Are they spouses? So, you know, the toothbrush, maybe they have 2 toothbrushes here, Bill, I don't know. So never, this is an absurd question. Yes, if they have children together, depends on whether they present themselves to their friends or community as a couple. Yes, if they've been together 3 years or longer or other. All right, so we're gonna actually answer this question, but let's see what our poll results are. 18% says never, 37% says yes if they have children, almost 40% says depends, as if they presented themselves as a couple. Yes, if they've been together 3 years or longer, and no other. So we're going to actually include a case in the show notes that actually very closely mirrors these facts. But before we get into the distinctions, let's talk about married couples and just to illustrate the differences. Adam?
Thanks, Russ. I'm just going to go through a couple of main similarities that common law relationships and common law couples have to married couples. And the first similarity relates to parenting when we talk about things like custody and access of children. So both parents, whether you're married or you're common law, are entitled to custody and access of a child. The Divorce Act recently changed the terms from custody and access to parenting time and decision-making time, but both married couples and common law couples do have, obviously, rights to the children of the relationship. Another main similarity common law couples have to married couples is both child support and spousal support. And the only main difference is that the act that is used to look at both these claims. So divorced couples will be governed by the Divorce Act and the federal child support guidelines, while common law couples will look at both the Family Law Act and the Ontario child support guidelines. And the requirements to make out a claim for support in either child support or spousal support are the exact same regardless of the act. And the amounts listed in the guidelines are almost identical. And they're really, so when you look at it, there really is no real difference between common law and marriage in terms of child support and spousal support claims. So those are the main similarities between common law and married couples.
That's great. And in your show notes, you're going to get a reference to our last poll question in a case called Clemens and Latner. They actually had separate residences and were dating. They're considered common law. Went to the Court of Appeal. The Court of Appeal upheld that finding. So you'll see that in the show notes that we sent to you. All right. So what are the differences, Adam?
So there are quite a few differences between common law couples and married couples. First is that if you are married, then the Divorce Act will govern your situation. So the Divorce Act would only apply to married couples and not to common law couples. The Divorce Act is a federal law, and it only applies to couples who are married and will deal with things like divorce, custody access, child support, and spousal support. Now, the Family Law Act is a provincial act and applies to both married and unmarried common law couples, and will deal with the division of property and debt, guardianship, parenting arrangements, contact with the child, child support, and spousal support. The matrimonial home rules are also a major difference between married couples and common law couples. Now, for married couples, if you are married, the matrimonial home is given very special treatment in Ontario. Section 18.1 of the Family Law Act defines a matrimonial home as every property in which either spouse has an interest or which is currently or was at the time of separation ordinarily occupied by the person and his or her spouse as their family residence. In Ontario, the matrimonial home is treated very differently than any other asset under the equalization process. Its value is never deducted from a spouse's net family property at the date of marriage as a date of marriage asset, even if that spouse owned the property at the time of the marriage. For example, if you buy a house prior to getting married and your spouse moves into that home, after you are married, this house becomes your matrimonial home because it is the ordinary resident by you and your spouse. And it does not matter who is on title of the home. If the parties live there as a married couple, the home is shared equally upon separation. Now, this is a stark difference between common law relationships. Like I said, there is an equal benefit in a property accrued during the marriage, but not in common law. In common law, if you own property and it is in your name, then you keep it. If the property is in your spouse's name, then your spouse will keep it. Only if property is joint will you be able to share in the property. Under the common law, there is no division of property regime. However, there is a way for common law couples, as Bill has mentioned, to divide their property, and this is through a trust argument, which we will get into further later on. just to summarize this, if you own a home and you are a common law couple, you are not entitled to share in that any increase in value from the date of marriage to the date of separation, unless you can establish you own an interest in that home and you bring a trust argument. And that is the exact opposite as a married couple. In a married relationship, you are considered to have a 50-50 interest in that home, whether or not you are on title or not. Another main difference between married couples and common law couples is that if you are married, you will need to get a divorce order from a court to show that you are divorced and you are no longer married. If you are in a common law relationship, you are not required to receive any kind of order from a court, and you can simply end your common law relationship by going your separate ways.
Really
Thanks,
great,
Russ.
really great summary, Adam. Thank you so much. Let's run a poll and then we're going to go to some questions. So can parents make a deal in which one parent does not have to pay child support? Couple questions we got in ahead of time. One of them, can you start living with another person and have a child while not being officially separated or divorced? Bill? I think you do whatever you want, right?
Can you repeat that, Russ? I didn't quite hear.
Can you start living with another person and have a child while being separated but not officially divorced?
Yes, you can. The only thing you can't do if you're still married to someone is marry someone else.
Yeah, yeah. But if you're common law, you
Yeah,
yeah.
go for it. Bring it.
Couple questions coming in online. Thank you, everybody. Will you give it the end notes to the webinar because somebody has an appointment? Yes, you're going to get a follow-up message from Stephanie with the show notes. This question isn't quite on common law, but it's kind of interesting. Somebody's ex hired a neighbor, friend, business associate. The person doesn't like it and wants the person to be removed. I guess he doesn't like it because they're friends, right? So we're not giving out advice, but generally it's frowned upon lawyers acting for immediate family members. Oftentimes friends go to the lawyers for advice. That's a little bit more of a gray area. The business might be, it depends if the business is related to the family assets. Maybe there could be a conflict there. Lots to unpack in that question. What do you think, Bill?
Well, that's right. Everything you said is correct. And also, I mean, if that friend has sensitive information that might be confidential or sensitive nature about you, then they kind of are in a conflict of interest. You don't want the lawyer representing your ex to know everything about you and about your business. So if there's a lot of knowledge there, that's going to be a problem.
Yeah, I think it's the smell test, right? Can this lawyer dispense dispassionate and fair legal advice? Or are they taking an interest in the case in some fashion, right? That's probably the line the court's going to look at, or the governing body. Another great, these are great questions. What happens when a couple legally gets married but remain in their own home in different cities? You want to take a crack at that one, Adam? I think you might have two matrimonial homes, right?
Yeah, I mean, I don't really see what the major issue with that would be. I mean, it depends whether or not the parties are going to be living together. I mean, if one, and I might be wrong here, Russ or Bill, you can jump in, but if the parties are living in separate cities, is there even a matrimonial home here?
But they're married.
They're not living together? Sure, they're married, but are they living together as an ordinary residence? I don't know.
It's not too different than the cottage cases, right? Where they go to the cottage a couple of weeks a year and that's treated as a home, even though they're
not. Are they? Yeah, I mean, we don't know if they're ever seeing each other. I mean,
that would be so weird though, Adam, if they were married and they never saw each other. Like that would just be bizarre.
It's sort of the reverse of that other case though, Bill, right? Yeah. They both had their own homes and they're considered to be common law because they went on vacations together, right?
Right.
So I think Adam's right.
I think we need,
fact.
We need a little more information.
Analysis.
But sometimes the best marriages are where the people don't live together and they never see each other.
Yeah. You're right, Bill. You know, there could be the facts are going to dictate the outcome, but there's probably lawyers that will argue both sides of the case, I'm sure.
Yeah.
So let's see what our poll results are. Can parents make a deal in which one parent does not pay child support? 26% said yes, 30% said no, 44% says it depends. I know you're going to talk about child support, Bill, but it's the right of the child. It's not the right of the parent. I don't know if you can contract out. Maybe the deal is they're prepaying support, right? I don't know. What do you think? Let's get into child support. See what you got to say.
Well, Russ, as you mentioned, child support is the right of the child. You're not allowed to bargain it away. You're not allowed to say, oh, don't worry about paying child support because it will come back to bite you in the you know what. You can pay different ways. You can say, well, instead of actually paying the table amount every month, I have this amount of money that came to the kid in this way, and it's equivalent. That's different. But saying you're not going to pay, it don't work. Forget about it.
All right.
Now,
what other insight do you have on child support?
well, I'm glad you asked, Russ. In the old days,
How many centuries are you going back? Come on.
I'm going back to the 1600s. No,
Okay.
in the
We only
70s,
have an hour.
child support used to be done on a case-by-case basis to see how much you'd have to pay. And this caused a lot of litigation. So in the 90s, the late 90s, they came up with a child support guideline and a child support table. And the table looks at how much you make, and then there's a number of how much you have to pay, depending on how much you make. So it's cut and dried now. It was supposed to have reduced litigation, but the last time I checked, Russ, the courts were still pretty full. But at least there's a table now. There's also an issue of being in loco parentis, or being a step parent to a child that's not yours, and what happens then? Well, the answer to that is, if you treat that child as, if you form a settled intention to treat that child as a part of your family, then you do become a step parent. And if you break up with that child's parent, you will be on the hook for child support as a step parent. Although you usually don't have to pay the full table amount because the biological parent will be paying as well. So, but yeah, it's a step parent child support obligation.
All right. Let's get into a poll and get back to some questions. Some of these questions are going sideways. What factor is not used in calculating spousal support? But I've got a question. Do common law spouses contribute to child support? The father's child is claiming hardship, but their combined income is more than biological mom. You want to take that, Bill?
Yeah. Doesn't really matter what the combined income is for child support. That only really comes into play for spousal support, which they used to call alimony. Then you do
Well,
look at
there are hardship provisions under the child support.
well, there, yeah,
I've never seen them. I've never seen them be successful.
Yeah,
they're there.
That's the other thing. So number one, you don't factor in your the partner's income for child support purposes. And if you're claiming hardship, it's extremely difficult to do. Basically, you have to have another child somewhere else that you're paying support for that's not really even in the picture. And you have to be in debt because of that child support. Like, you have to be really, really in financial trouble, and it's got to be because of a child support debt from someone else. Then maybe you will succeed in a hardship claim. Otherwise, not really a good idea to try it.
I think the court's going to be of the view you chose to have another child. You're on the hook. Yeah. But I'm thinking our audience is having some fun with me here with these questions. And I don't even understand, before we get to the poll results, would this change? I'm not sure what question we're talking about here. Would this change in the instance of a friend or someone acting as a sperm donor in terms of contracting to avoid child support? So I think what that question is asking, are sperm donors off the hook?
Yes, they are.
Yeah.
Sperm donors do not have to pay child support unless A lot of times the donors are anonymous, but if you know who the donor is, and if it's like a friend, and then they form a friendship with the child, even though they weren't supposed to, then weirdly, the sperm donor becomes a step parent. I'm not joking. That's how it works. And then they have to pay
So-
support as a step parent, even though it's their biological child.
If you're helping a friend with benefits to get pregnant, as long as there's no relationship, you're good, or
Yeah, as long as there's
you
no
have to be
relationship. with-
classified as a sperm donor to officially skirt your duty.
Yeah, if you're just a donor, you don't have to pay support. But if you start hanging out with the kid, then you become a step parent, even though it's your biological child. Very weird, but that's how it works.
Okay.
But
Okay.
the other parent, the other parent would have the onus to prove that.
Yeah, they sue you. That's what happens. I've seen it. I've been in cases like that. Suing the donor.
Well,
happens.
no, the donors giving birthday cards and showing up at Christmas time with gifts.
Yes.
There's evidence that you assemble,
Yeah.
right? We've seen it all.
Yeah.
Posting social media pictures with the child, right? Okay, so we're going back to this two-home situation. Sorry. They both have professional practices. They spend vacations, weekends, and other possible situations together. They co-own a cottage and another cottage. Well, I think you're going to have multiple homes if they're married. You're not going to be able to exclude a home unless, it's not the home you bought on the date of marriage, right? You get that one quirky deduction. But all right, these questions are giving me a bit of a hard time, but they're great. Keep them coming in. So let's go back to our poll. Not used in calculating support. Length of a relationship, 2%. Age of the recipient, 0. Infidelity, 95%. Whether there are children in the relationship. Well, pretty sophisticated audience today. I think those are pretty accurate answers. I think we're talking about spousal support. Is this one, who we got up here?
Yeah, I'm up here, Russ.
Okay, and also we got
All right,
show
let's
notes
move on.
coming. All this stuff we're talking about child support, we got show notes coming to you about that as well. Sorry, go ahead, Adam.
Yeah, let's move on to spousal support. I'm just going to be wary of the time here. It's almost halfway through here. All right, so unlike child support, spousal support is more negotiable. There's a lot more gray area than child support. And when you're looking at spousal support, you're looking at a range, a low, medium, and a high range. So it's not just going to give you one number like child support would. And these spousal support advisory guidelines are the starting point to determine what spousal support may or may not look like. So the definition of a spouse in Ontario says that any common law spouses have the same rights to spousal support as married couples, as long as they've been living together for at least 3 years, or if they have a child together and have been living together in a relationship of some permanence. So
I love some permanence.
Some permanence.
What does that even mean? It's kind of permanent, but it's not. Anyway,
So
sorry.
you
Adam.
can get in a fight, one goes lives with their mother and then come back. They come back and all right, sorry, Adam.
Sorry to jump in, Adam.
So there are several factors that you need to prove in order to establish entitlement to spousal support. And the spousal support advisory guidelines will take into account many factors in determining what proper spousal support should be. They'll look at the incomes of the parties, they'll look at the length of the relationship, and they will look at the ages of the parties upon separation when trying to determine what a quantum and a range would look like. So let's talk about entitlement. There is not an automatic right to spousal support in Ontario, which is unlike child support. Like I said, it is a lot more gray and complex when looking at the differences between spousal support and child support. In Ontario, you are only eligible for spousal support under these 3 factors: to compensate a spouse for hardship or opportunities lost due to the marriage or common law arrangement or its breakdown, to fulfill a contractual agreement, expressed or implied, that the parties were responsible for each other's support, or on a non-compensatory basis to assist a spouse in need where there is a capacity to pay, even in the absence of a contractual or a compensatory foundation for the obligation. So now let's look at the length of the relationship as a factor. The spousal support advisory guidelines serve as a starting point for quantum and the duration of support. So instead of generating a definite number, the advisory guidelines formulas will provide ranges for both the amount and the duration. And then a court can choose to follow the guidelines or depart from them in any particular case. They will provide a range and a duration for monthly spousal support payments, but spouses are also free to negotiate the possibility of a lump sum payment. The guidelines are largely used and based on the length of the cohabitation and or the marriage. The advisory guidelines will also look at whether or not there are children in the relationship. When there are not children in the relationship, the support duration ranges from half to 1 year of support for each year of marriage or cohabitation, with duration potentially becoming indefinite after 20 years of marriage. So since one of the factors in determining spousal support entitlement is age, the advisory guidelines suggest that indefinite support sorry, I just lost my train of thought here. Sorry, the advisory guidelines suggest that indefinite support, if the marriage has lasted 5 years or longer, and the years married added to the support recipient's age at the date of separation total 65 or more.
We're going to get to that.
This
Don't spoil my next poll.
We're going to get to that. It's called the rule of 65.
Okay, let's run the poll.
And this
Let's run the poll, because I want to hear what the audience thinks of this rule of 65. And while we're waiting, we've got more questions coming in, which I love. Couple property questions in terms of $100,000 down payment, stay at home, upgrades in their joint tenancy, 50-50. If you're common law and you're on title 50-50, you're going to get your share of the property. But there's cases I've seen where people come in and pay $100,000. The court will give them that $100,000 back first before they split up the difference. Another one is X left 3 years ago. They appraised the house at that time. And then they're wondering, do the appraisal stand or do you use market value? We've got a lot of this going on right now. Market's gone crazy, probably increased by a few $100,000 or more since the date of the appraisal. I would say you probably need to be on title if you want to share the increase, especially if you've not been in the home and not contributing. If you're common law and you've had the home's in the other partner's name and you have an appraisal as your date of separation, you're probably going to get stuck with that number. What do you think, Bill?
Well, the cases go both ways on that, Russ. You're right, but I actually just did some research on this, and there is really strong case law now that says even if you're not on title, and even if you separated 3 years ago, they still value the house as the present day. So there is, that can happen. Even though you haven't been in the house, you're not on title, you still can benefit through a trust claim, through the increase in value.
Yeah, you and I have looked at that a lot, Bill, over the past.
It doesn't seem fair, but that's what some of the courts cases have done.
That might be the exception, not the norm, but.
No, it's not. It's actually really, it's getting to be the rule now.
Is that right?
Yeah.
Okay. Another one.
So the answer is don't separate.
Or settle your case.
No, stay together.
Where a common law partner has been paying mortgage for over 3 years, being kicked out by the spouse, rights can she proceed with the sale of the house if it's in her name? Well, you could probably obtain a certificate of pending litigation until your rights are determined and cloud title to the property to prevent the sale. Might give you some negotiation leverage as well. Really great in-depth questions here, though. Thank you so much. I'm glad Bill's here with the correct answers, because I would probably get it wrong.
I'd like to make a quick suggestion, Russ.
Sure.
I'm going to devote the rest of my career to seeing if we can change the name of spousal support back to alimony, because it's such a better word.
Is that? It's sort of an American term, isn't it?
The American term, yeah.
You say that like it's a bad thing.
No, it's
in England they call it maintenance. That's cool too. Maintenance is cool. Alimony is cool. But spousal support is lame.
Like you're maintaining your car, you're changing the oil.
Yeah, it's kind of like that.
Hang on. What happened to our poll results? Did I miss them? I was talking too long. Okay. Does the rule of 65 apply to common law spouses? What's the rule of 65? 35%. No, 10, yes, 30. Depends on the facts of the case. Okay, so let's get back focused on topic. Rule 65, Adam, help us out here.
Yeah, so I'm gonna read from the slide here because it's a little complicated. The rule 65 is when there's indefinite, but doesn't always mean forever. I know that's a little confusing as well. Support will be available even in cases where the marriage is shorter than 20 years. If the years of marriage plus the age of the support recipient at the time of the separation equals or exceeds 65. This is known as the rule of 65. For example, thus, if a 10-year marriage ends when the recipient is 55, indefinite support will be available because the years of marriage 10 plus the age of the recipient 55 equals 65. This refinement of the formula for duration is intended to respond to the situation of older spouses who were economically dependent and disadvantaged possibly during a medium length marriage and who may have difficulty becoming self-sufficient given their age after a separation. So that is the rule 65 broken down.
Really important. Lots of people forget that this rule is out there. Actually, an interesting Court of Appeal decision where spousal support was terminated even though the rule of 65 applied. Fairly recent case. So it's not forever, but it's indefinite. Only lawyers would come up with that kind of rule. Okay, so let's run another poll. What we got up here now? Get my poll question out. Should the Family Law Act be amended to provide for common law couples to share property like married couples? Yes, share everything. Yes, but share only the home. No, don't share anything if they're not married. Other. So we've got lots of questions coming in while we vote. Somebody wants to know how long you have to make a claim. Bill's going to talk about limitation periods. Oh, what was somebody saying we didn't answer the question? Sorry. The rule of 65 does apply to common law spouses, right, Bill?
Yeah.
Yes.
Sorry if we weren't clear on that. It applies to married and common law spouses. And sorry, I'm just trying to go through these questions that are coming in kind of rapid fire. We're going to talk about the limitation period. Adam, you're going to get an email from somebody. Hopefully it's nice. Co-have agreements, that's probably a topic for another live event. It's going to be pretty in-depth. For spouses on common law, does the age factor change the formula in terms of duration? I think the answer would be yes to that, right, Adam?
Yeah, I think so.
All right, let's see the answer to this poll question here. So amending the act to provide for common law couples to share, 16% said yes, 16% said yes, but home only. 52% said no. They're not married. So, you know, I guess if you're married, right, you've got certain rights that you're entitled to. So there's a point there. And then other. All right. So I think that ties in neatly with our next subject matter, which is property. Who's got this one? Adam?
I got this one, Russ. Let's move on to property. So as previously mentioned, under the common law, you get what you bring into a relationship. Anything that is in your name is considered to be yours. Anything that is in the opposing party, the other person's name, is considered to be theirs. That includes any assets, debts, or any other obligations. Any jointly owned property is treated as a joint asset and is shared equally upon separation. So let's talk about the house. If you are both on title of the home, you share it equally, meaning you split the proceeds upon a sale, or there could be a buyout from one spouse to the other. If only one party of the relationship is on title of the home, it becomes a lot more complicated and could give rise to the trust claims, as we've already discussed. However, it is very difficult to make this argument, and the onus is on the party to bring these claims to prove their entitlement to the interest in the home. The common law property is not the same as a matrimonial home. There is no legal right to possess the home, and a trust claim is needed to be able to obtain an interest in that property. Now, trust claims started as under the law of equity, and whereby it would be unfair or unequitable not to share in the value of a property's increase. And there are different ways for a common law party to obtain property and or money from that individual property, from the other spouse. One way to proceed is by something called a constructive trust. A constructive trust allows a cohabitating spouse who is not on title to gain a right to a property in a particular asset, such as the home, whereby that cohabitating spouse who has stayed in the home, maybe with children, and completed some housework or domestic services of a home, may be awarded a monetary award or a constructive trust over the home, where their contribution is connected to the home itself. A spouse who is seeking a constructive trust must establish 4 different requirements. They must be able to prove that their contribution of either money or labor enriched the legal title holder of the property in question. They have to prove an enrichment of the other spouse, resulting in a corresponding deprivation to the contributor. They must prove that there is no jurisdiction reason for the enrichment, anything that might be explained whereby there any contract or gift, and there must be a connection between the contribution made and the improvement of the property in question. Another way to proceed is a resulting trust. A resulting trust arises when one individual pays or helps pay for a piece of property, yet legal title still vests with the other individual. It would seem unfair to not allow that individual who funded the acquisition or the property to retain some interest in that property. Therefore, he or she may become a beneficial interest holder and a presumed legal title holder, and holding a legal title holder is being held as a beneficial owner in a trust. And the main differences between a resulting and a constructive trust. A constructive trust allows an individual to share in the value of a property, even though he or she is not a legal title holder. This is due to the fact that they helped contribute to the value of the property through other work or money, making it unfair to deprive that person from a share in the increase in value of that property. Unlike a resulting trust, there is no need to find any evidence of a common intention to establish. Now, the final thing to look at underneath trust claims is a joint family venture. A joint family venture occurs where, during a relationship, both parties contributed to the accumulation of family wealth, and it would be unjust for one party to make a claim against the other party. An unjust enrichment arises if the parties separate and one party retains a disproportionate amount of the accumulated wealth. To make a claim for a joint family venture, you have to be able to prove 4 factors: that there is a mutual effort by the parties, there is an economic integration of the parties' finances, there is an actual intention of the parties, and there is a priority of the family. Thanks, Russ.
Really, really helpful. And we had a lot of questions come in on these trust claims. These trust claims can get complicated. We do have a common law 201 advanced themes live event. So if you want to learn more, take a deeper dive, go to the advanced version of this program that we're presenting. It'll be on the schedule that we send out. All right, so let's do another poll question. It's been a couple minutes. We got to get back to the polls. Which of these factors is not an indicator of a joint family venture? So I think if you're listening to Adam, you'd know, right? Like if you're taking notes, mutual effort, loyalty, no infidelity, economic integration, priority of the family. And just a reminder, all difficult questions go to Bill. Adam and I are going to take the easy ones. But the questions have been fantastic. Thank you so much for sending in the questions. Let's go into our next topic, which is parenting rights and responsibilities. But here are the poll results. And yes, our audience is getting it. 91% infidelity doesn't affect your claims. Very good. Pretty tuned in audience today. So parenting rights, Bill?
Yeah.
Sorry, did you want to cover anything off about joint family venture? I thought you did a great job, Adam. So that means
Um,
parenting.
I think
rights.
I think he covered it off okay.
Yeah, I did good work.
Yeah. I just want to say that infidelity is something like a lot of people say, look, my partner cheated on me. Doesn't that mean anything? And the answer, in law, it does not, as you just said. But personally, I think the person who cheats should at least get a ticket. You know what I mean? Like a traffic.
Well, Bill, that's a question. That's a question we get almost every day, right?
Yeah.
Yeah. And the
Well,
answer is
I
no.
get
It used to matter in the
Yeah.
old days.
The question is, do I get more? They cheated on me, right? So why
Yeah.
did they get half?
It doesn't mean anything, but it used to in the old days, but they changed it all to no fault. So just again, I think they should get a ticket. Parenting rights. Parenting is the same as Adam mentioned. Just doesn't matter if you're married or not. The law is exactly the same. And one interesting aspect of parenting is something called status quo. And the courts want to maintain status quo, generally speaking, because they want stability for the kids. So if the kids are spending every second weekend, let's say with dad, that often happens, and then dad wants to jump to a 50-50 schedule, it can be done, but it's not going to get done overnight because the status quo is just every second weekend. They want stability for the children. So if you want to increase the parenting time, it's going to take a lot of patience, and it's what's in the best interest of the child that matters. The status quo is super important for that. The other interesting point to me is that parenting time and decision-making are two different things. So deciding about the kid, things like education, healthcare, religion, extracurricular activities, those big decisions, they have nothing to do with where the kid lives. So you have to treat those as separate issues. Sometimes you'll get, and then, a lot of times you'll get 50-50 residency, and all the decisions are made together. And that's typically the best way to do it for the kids. But there's a million different fact scenarios out there. It really depends. The voice of the child, last point here. People say, well, we want the voice of the child to be heard. And yes, the voice of the child should be heard, and it usually is heard by the courts. But if the kids are young, it's not determinative. The court will take into account the views and preferences of a child, but it doesn't make the decision. Kids are too young.
Great stuff. We've got questions about limitation periods for unjust enrichment. We're going to get to that. But before we're going to talk about limitation periods, Adam's going to talk about what happens when common law couples separate.
Yeah, so like I already mentioned, there's no need for any court order or divorce when common law couples separate. Normally, when common law couples separate, the parties try to deal with these matters out of court if possible. They try to draft a separation agreement. They potentially could go to mediation. They'll negotiate the terms potentially. They will potentially go through the collaborative process, all in the hopes of being able to try to obtain a separation agreement. And if the couple is unable to agree on terms, then they may be forced to proceed to court. And if the parties have already had an agreement in place, or they had a court order, and they want to try to change that, they can attempt to do that by way of negotiation and then drafting a revised or amended agreement. If they had a court order in the past and they want to change that, they may have to go back to court and bring a motion to change if they're unable to agree on the terms, to try to get a new order in place. So those are some of the things that common law couples will have to do upon separation. But we always push to try to resolve things as amicably as possible, outside the court system, which will save what we find our clients a lot of stress, time, and money as well.
Really helpful. Thank you, Adam. Let's go to our final poll question. Are limitation periods to make claims for common law couples the same? We're going to get to this in a minute. So everybody put your answers up there. Then we're going to wrap up with limitation periods, and we're going to bring our host back and do some more Q&A. So thank you, everyone. Question from our audience. Bill, for common law court case, litigants need to file Form 13-1 financial statement or Form 13. Depends, I guess, right? If you're making a property claim.
Yeah, I just dealt with that very question. The 13.1 is the one that has property, and it's the one that married people use. So if you're not married, why would you use a 13.1 form that shows, what you had on the date you got together and what you had the day you separated? Normally, you don't use that for common law, but the common practice now among family lawyers is that they do make a 13.1 financial statement, even if the parties aren't married. They call it a mock-up.
But the court needs the information to evaluate,
well,
right?
Yeah. So it's a good idea to do one, and you kind of look like a jerk if you're a lawyer and you refuse to do one. So it's kind of weird. It shows that common law are being treated more and more similarly to married people, and that's a good example. They do use that paperwork a lot of times, even though it's not really, strictly speaking, applicable to common law.
But if you put the issue squarely before the court's going to order the disclosure to make an
Yes, absolutely.
an evaluation of the claim. So let's take a look at our poll results here. Are they the same? Yes, 20, no, 27. Depends what claims are being made. What is the limitation period? Yeah, I ask myself that question sometimes. Got some great questions coming in about foreign properties, question coming in about offsetting occupation rent. We'll try to get to those. Just give us a few minutes, but let's talk about limitation periods, and then we're going to go into Q&A. So Bill, 2 minutes or less?
Yeah. The limitation period for common law people for making a property claim, which, as we've discussed, is a trust claim, because you're common law. If you are making the claim with respect to a piece of real estate, like a house, and almost all these claims do, almost all these trust claims do involve real estate, then you have 10 years from the time of separation. So that's a lot of time. If you're making a trust claim but there's no real estate involved, which is highly unusual, then it's iffy. You may have a 2-year limitation on that from date of separation, but it's very iffy and very flexible, and you can probably extend it. Usually there's real estate involved.
Last time we did this, we had a good analysis of whether a claim could be made against a pension.
Yeah.
I said
Yes, it can. Yes, it can.
I said I have never seen any, and we talked about it. Adam gave me a case from Madam Justice Kraft where probably the first one I've seen that a claim would be made against pension. So not to put you on the spot, what would the limitation period be for that? 10 years?
Well, pension is not real estate, so it wouldn't be 10 years for a pension. It would be maybe 2 years. Like the starting point is 2 years from date of separation, because a pension is not real estate. But again, that 2-year limitation is highly flexible. It's never been litigated, but I would say you could extend it.
But if you're worried about a limitation period, get in and talk to a lawyer. It doesn't have to be one of us. Talk to a lawyer, make sure you're not going to have an expired claim, because then you're going to spend more money chasing it down. So I think our host is going to be coming back up. Great analysis, Bill. Thank you so much for sharing that. And do some Q&A, and then we're going to bring this train into the station. Steph, welcome back.
Thank you, Russ. All right, so we had a lot of questions coming in. Russ, are there any that stand out that you want to tackle before we close off?
There's just so many great questions, right? It's hard to pick one.
It was a foreign property question.
Yeah, how do foreign
somebody's
properties
asked.
get split, such as cottages in different jurisdiction? I would say they're divided in accordance with the Family Law Act. The more important question is, how do you enforce it, right? If you got a villa in Spain, you're going to need to enforce an Ontario order if the other spouse is not cooperative, or offset it against assets in Ontario. What do you think, Bill?
Yeah, you end up if they don't cooperate, you end up offsetting. Like, you'll take the foreign property into account, and then if they're not going to sell it and pay you what your share is, then you take it out of something they have here.
Okay.
You also have the issue of determining the value, right? I mean,
Yeah.
getting something appraised overseas would be a lot more difficult than getting.
I
it
recommend
appraised
going directly to Spain and making a disbursement about that. Have a holiday.
Steph, one more, I'm just gonna jump the queue here because this is a big question, but I think the gist of it is for trust claims against a property, how is occupation rent treated and set off? So if you're occupying somebody else's portion of the property, there's a notional occupation rent there. Maybe not if they don't own the property, right?
Normally, occupation rent is for people who are on title.
Right.
And it's very, very difficult to get occupation rent. It all sounds good, but you can basically forget about it.
Well, the person has to be either excluded by a court order or conduct that they can't return to the property, right? It's a fairly.
And even then, it's hard to get.
Yeah.
Very hard.
It's a challenging claim, correct? Yeah, I agree with Bill.
Yeah.
I mean, you could try it, but
Last
It's good to
question.
talk about it because it makes you sound really sophisticated. Just keep mentioning the word occupation rent, but no, you're never going to get it.
Well, it's a new, people use it as a nuisance way to negotiate a resolution, right? Occupation rent claims 80 grand. I want to set it off and, they'll blow off $30,000 in legal fees talking about it. It's not a very practical claim, I think is what you're saying.
Always
All right.
make it though.
How's our time, Steph?
We are coming to a close. It's 12:58 now.
Yeah, we better wrap it up. This has been
All right.
fantastic discussion.
It's amazing. We had so many questions popping in. So thank you again, Adam, Bill, and Russ. And thank you everyone in the audience for taking the time to join us for today's presentation. We hope you found the content helpful, and just keep an eye out for that follow-up email with links to helpful resources that were mentioned in today's presentation. So we'll be sending that out tomorrow. If you do have any questions about our virtual event series or any comments for our team, please feel free to reach out to me at stephanie@russellalexander.com. There will also be a survey that pops up in your browser following the webinar. So if you have the time, we welcome and appreciate any feedback you have from today's session so we can take it into consideration as we continue to grow this virtual event series. One of those questions, you are able to comment on any topics that you'd like to see our team address in the future. So we do host these virtual event series bi-weekly on Wednesdays at 12 p.m. on a variety of family law topics. So our next presentation will discuss divorce and family business valuations, tips and best practices, and that's on Wednesday, February 9th. So we'll be including a list of all of the upcoming webinars in our follow-up email. So if you are interested in learning more, check that out. And thank you so much again for attending. And thank you so much, panelists. You were amazing as always. And we hope you all have a lovely weekend.
And our next presentation has Melanie Russell and Jason Kowalski, which are just fantastic experts in business valuations. So you're not going to want to miss that one. It's going to be a really good discussion. Steph, we got 12:59 on the clock. You going to give us a sing out here or what?
I don't think anyone's ears want to hear that.
It just flipped over to 1 o'clock. Just flipped over to 1 o'clock. You're right on time. Thank you so much.
Saved
Steph.
by the
Thank you,
bell.
Bill. Thank you.
Thank
Adam.
you.
Great job today.